All right, thanks for joining everybody. It's December 4th. How did we get here so fast?
Right?
Already December. I appreciate you joining. I hope you enjoyed your Thanksgiving time. And so this evening, we're going to talk about, well, what I want to do is give you guys some language, some words, because think of it like this. If you are a victim of a crime, let's say, but you can't describe what happened to you, do you have a remedy? If your house was robbed, by burglars, burglarized, and you know it was wrong, so you call the police and the police say, what happened? And you don't know how to say it, what's going to happen?
Nothing.
You have to be
No
able to
report.
express something
Yeah.
somehow, right?
Yeah.
So the purpose of partly what I'm wanting to do tonight is to give you some language, give you some understanding of something so that we can therefore identify a problem or identify the source of a problem. Let's call it a problem because maybe it's not. Maybe it's a thing that we don't like. It may not be a problem. And then if you want to do something about it, you can do something about it. We have the remedy. So, but first we have to talk about what the thing is that that we need the remedy for. And so you'll see so Jim and I have been toiling away at this aceofcoins.club. We added some, things there. We're trying to make more videos more accessible. And then lately we started partnering with Todd Pittner and Mike Adams over there at Brighteon and talking about the UNA. So that's kind of an interesting organization. They like to promote that. I'm always going to promote LLCs, but if people like to use a UNA, I just look at them like an irrevocable trust. And I like to think that I like to write the bylaws for them in such a way that it functions properly the way it's being marketed. So I think that it's a pretty solid structure. So, anyways, that's what you're gonna see some videos on that.
Mm.
I put that video series together. It's 4 videos. I put that together for the people that are using UNAs. So I believe it'll give them a good start on how to place it in whatever they're doing. So aceofcoins.com is still a place to schedule time with me, do a individual consultation uh, and look forward to talking to you guys. And by the way, when I schedule those, as you know, I just I schedule follow-up interview discussions, uh, 2 or 3 that don't cost anything. So when you pay for the initial consultation, it's assumed that you're going to call me 2 or 3 more times, sometimes 4. It's okay. It's also assumed that I'm going to maybe prepare some documents for you or give you some references. I'm going to do a minimal amount of work to hopefully get you started on something. And then if you want more consulting, then certainly have that program. And that again is available at aceofcoins.com. So a UNA is an unincorporated nonprofit association. So looks like the latest trend of things that people like to use for holding title to property. Uh, I don't want to talk too much about that, but this evening I want to get into the collection, use, and storage of biometric data, but I'm going to back up to I believe, the origin of the ability of private companies and government agencies to, let's say, impose the terms of that result in the collection of your biometric data. Okay. And I'm going to demonize the bar. Okay. Your state bar association. And I'm going to give you some language here. So the way I did it is this. I want to I want to describe the boundaries of what the bar has created, what the bar is doing. And I'm going to give you some language for that. But the way I'm going to do it is from the perspective of someone who's been indicted for the unauthorized practice of law. And so my purpose here is to help you see the wall, the boundary that's been created, the prison, if you will, okay, that's been created in our society. But don't freak out because we still have remedies, okay? But just understand what's there. There's a thing that we can see. We can't see it unless we describe it. So let's just say that somebody was indicted for the unauthorized practice of law. It's not the unlicensed practice of law, although that you may see language like that, but it's the unauthorized practice of law. And so I'm just gonna I'm sorry if I have to read some of this, but I don't want to miss anything. It's important to understand how we got to a point where your data can be collected and it's now money. It's almost a commodity. Okay. Um, so first of all, we have an organization. It's a private labor organization, private association of professionals that organized themselves in many states. I know in Florida it was in 1948 or so, for the purpose of excluding others and also imposing criminal penalties on those who were not members of the association that was formed. So isn't that interesting? Imagine creating a labor union and then making it a crime to not join the union if you work for the same company. How interesting would that be? And so that's what the bar has done. There were many, many lawyers at the time. In Florida, it was 1948. So all this took place post World War II, I think, for the most part. And imagine being a professional lawyer, a lawyer, attorney, and suddenly a bar was formed. And if you didn't join, all of a sudden your job was illegal. So, of course, that's not true. It never would be true. But what happened was when the bar was formed, it got incorporated into the court system, and uh, because then all the members of our legislatures, our state legislatures, were members of the bar by that time. It was so easy then to create a statute that made it a crime to not be a member of the bar if you were involved with the practice of law. See how that works? So the Bar Association is the group of professionals that write all of our laws, including licenses to do things that would otherwise be illegal, like business licenses, professional licenses. Lawyers write all those laws, but yet lawyers themselves are not licensed professionals under public funds. The attorneys are not licensed under the executive branch of government, which is the proper function of that because the executive branch of government is the tax collector and the police power. And that's the function of government that's going to impose licensing terms and fees and collect the revenue from it. Lawyers don't pay that. There is nothing to pay. There's no licensing for attorneys. There's only membership in a private association. So what I'm going to say is from the perspective of unauthorized practice of law, it's a fabrication of a private association, or it's a fabrication. The state bar, it's not cognizable. It's not a cognizable offense to not be a member of the bar, okay? Because that offense, it is a law. It's on the books. I don't know that it's been challenged for its constitutionality, but let's just make the argument here that an offense for the UPL, as they call it, is grounded in it's not grounded in a legitimate exercise of the state police power for what I just explained. The state police power would be where there's a licensing requirement for those engaged in such a profession, and yet there is none, but yet there's a thing called the unauthorized practice of law, but that can't be enforced because you can't be required to join a private club as a professional to be in that profession. There are certain limitations on, or there should be limitations on, qualifications. Like, for example, if you're a lawyer and you're not a bar member and you're incompetent or you're negligent, there are consequences for that. Okay. But anyways, the indictment itself would have criminalized non-membership in a private association. So it violates your fundamental rights of association and also access to the courts. It conflicts with longstanding legal principles and rests upon powers the state bar does not and cannot possess. So courts have no lawful authority to enforce this indictment because no branch of government may impose criminal penalties for refusing to join a private membership organization. Makes sense, right? So the state bar is a private membership association, but it's not a government agency. Now, here's why. The bar is privately funded. It's not funded by tax dollars. It's governed by its own members. It's the only organization that governs itself and yet writes laws for everybody else to which it doesn't have to comply. It's not an arm of the state. It's not a branch of the court. It's not created by statute or it's not created by the Constitution, and it's not accountable to the public. And that's the important thing. It's not accountable to the public because it's not funded by public dollars. So let's see, criminal association. So the state cannot use public funds to impose criminal penalties for not joining a private club. Okay, so the state has therefore, no compelling interest that would justify using tax dollars to punish a person merely for refusing to join. So how useful is this association? Well, it makes what those professionals do so uniform that they can get away with what I'm going to describe as writing procedures, policies, and contracts that allow private companies the indemnification that's necessary in order to collect your data. So these contracts are written like, for example, your phone contract. Okay, if you ever want to read it, it's like probably 47 pages. It's probably more than that. If you're ever able to read it and print it out on paper, for example, how could you ever how could you ever give consent? I mean, the contract is so complex and lengthy that you can't possibly give consent. So these lawyers are writing all this stuff to survive a challenge in the court system. They're deliberately doing this to indemnify the company so that the train of collecting your data cannot be stopped. The lawyers are doing it. So let's just go on and see. I'm still fleshing out this border here, this boundary. Um, let's make an analogy. The state cannot criminalize the non-membership in the electricians union, for example, or the roofers union, and it cannot criminalize non-membership in the bar by the same rule, by the same understanding. So the unauthorized practice of law does not exist as a legal concept, really. Now, I would counter that a little bit. I would add to that and say, if you're a bar member and you get disbarred for some good reason or whatever, and then you afterwards are engaged in the practice of law, I think that should be considered unauthorized practice of law, in which it is, but not just because you're a lawyer and you're not a bar member. That is not the unauthorized practice of law. You're not needing the permission, okay? Um, so it's not a cognizable legal principle. There's no statutory licensing for the practice of law, as I just said. It requires a payment of a tax. A license requires a payment of a tax. You get a certificate. There's a receipt. There's a receipt for it, not a bar membership dues payment. There's a state licensing board. For example, if you're accused of negligence or incompetence, someone can oversee your conduct. Who's going to do that with the bar? The court? Have you ever tried to file a complaint against a lawyer? You know it's going nowhere, right? They're going to protect their own. Yeah. So there is no remedy in that way. So you're denied a remedy because of the nature of the organization. There can be no unlicensed or unauthorized practice of law of something that the state doesn't license. The courts regulate procedure. So if you look in your constitution, it'll say the court can regulate the practice of law in the courts, but that means it can regulate the procedure by which it functions. Okay, not who the public may choose as an advisor. The constitutions allow Supreme Court to regulate practice of law in the courts, the procedure for cases, but nothing authorizes them to regulate legal advice in society, restrict private consultants, create criminal penalties for non-members. There is no judicial authority. There is no constitutional authority for that. So such an indictment would exceed judicial power. So even though there's a statute for it, it's unenforceable. So in order really to prevail in a UPL case, you'd actually have to challenge the statute under which you're being charged, and you'd have to argue that it's unconstitutional or legally unenforceable against you, against yourself, okay, for whatever reason. So, but even if UPL were real, let's see here. Yeah, the bar's stated justification is a legal impossibility. Okay, so the bar claims that the laws, the UPL laws, protect the public against bad legal advice. Does anybody want to hear this? Does anybody want to know what the other side of that is?
Yes.
If Yeah, so if the practice of law is regulated by the court, by the bar, for the purpose of protecting the public against bad legal advice, what does that imply?
The
That
bar
I'm not
That there's bad legal advice out there.
okay, but then
Yeah.
it implies that if I make my own legal conclusion, it implies that my knowledge of the law is not required.
And it is required.
Yeah, aren't we all required to know the law? And
Yeah.
aren't we all bound by
Right.
the law?
I was just thinking that while you were talking. It's like we have
Okay.
all these rules. Yeah, yeah.
So if there's a law that says, no, we need the bar to protect you. No, you can't protect me because if I make a mistake and make a wrong legal conclusion, I'm liable for it. No one can indemnify me. No one can indemnify me for making a wrong decision regarding the law. If I break the law, that's my fault purely. No one can indemnify me. I can't hire a lawyer and then go break the law and say the lawyer said I could do it. I'm liable.
Right. But you can use a lawyer to get out of it.
Yeah, well, okay. But I'm just saying the premise of the bar is a lie. It's a
Right.
legal impossibility.
Yeah.
So if you even look at this is the funny part. If you look at the formation of the state bar in Florida, it just says the bar is formed for for the benefit of the bar members. That's what it says in its
Wow.
founding charter.
Wow.
No one's getting that. No one's reading that stuff, So you cannot indemnify anyone against bad legal advice. So the bar cannot exist for that purpose. The premise is false. You cannot, no one can guarantee competent representation. But there is a remedy for negligence and incompetent representation. There are remedies for that. So we don't need a criminal statute and we don't need a bar association for remedies for people that suffer these consequences.
Right, right. It's
Yeah.
already there.
Yeah.
Hmm.
No
The
one
bar
can
is
assume
used
financial.
to waive your rights, is what it does. They
That's what it does. Yeah. It's
represent you
actually
instead of present
what
you.
they're doing is they're seeking to own the law and then ration it out to people and only certain aspects of the law. So you're being denied access to the whole entire law. You're only allowed access to, so that way we can still operate in a feudal society and therefore people don't have access to property rights. Certain property rights is how I like to explain it. The bar can't protect the public. So this contradicts the fundamental doctrine that everyone is presumed to know the law and ignorance of the law is excused. Law excuses no one, right? So if the public must know the law regardless of advice, then it's logically impossible for the bar to protect anyone from ignorance or by policing non-members. So they're not policing competence, they're policing membership.
Uh-huh.
You see how powerful this is what I'm getting
Yeah.
at. This is
Yes.
so pervasive in our society, it's locked in. And rather than take that on, I mean, we could take it on. What I'm saying is, I think we could each get out from under this boundary that we find ourselves in, okay, this matrix, if you will. So an indictment of UPL would have violate the right of association and the right to counsel. I'm not going to get into that too far, but you guys understand, okay? So the bar cannot dictate who an individual chooses to rely upon for legal understanding, counsel, consultation, or advocacy. It's funny because back in the 90s, my partner, who was basically my mentor when I was learning all this, he would come into court and we would just pick cases like traffic tickets, right? We'll go in there and argue a traffic ticket. So my partner would show up in his jeans and t-shirt and rolled up sleeves with a cigarette pack in his arm, right? But yet he'd have like 27 volumes of law and two boxes with law books and stuff. And he had read them all. This guy was so smart. And he would go in there and the prosecutor would have like a piece of paper, and he would make the opening argument because what happened is the judge would recognize, of course, this guy's not a lawyer. I'm not allowing lawyers to come in my courtroom dressed like this. Who are you? And he would say, counsel for the defendant, Your Honor. And he'd say, are you a bar member? And he'd say, no, Your Honor, but that doesn't violate right to counsel. And then he would go stand there and make an argument as to right to counsel. And the judge would almost always say, well, that's really interesting. I can't wait to hear what you have to say. And he would almost always win the cases. So, it's just, you can make the argument. It's just what happened. I think in the late 90s, it changed. I think that the bar finally had enough of people standing up and they said, let's just annihilate these people. Let's just threaten the judges. Let's implicate the judges in UPL and they'll stop it. They won't let this in our courtrooms anymore. And which is what happened. So we stopped doing that. I remember the last time I was in an administrative hearing. It wasn't even in a courtroom. I was in an administrative hearing and I'd said nothing. It was the only, I went to the second hearing for a client and I said nothing. And the judge, the administrative law judge, started a fight with me in the courtroom. And I never made eye contact with him. I never said a word to him. And I had already advised my client that he was probably going to do that because what we did is we got Wells Fargo we got him, we caught him with their pants down and they had to pay a lot of money to my client and they did pay, but they were trying not to. And so the judge literally chased me out of the courthouse. I had to go hide. I had to go into the hallway and, you know, pull a Ben Kenobi on him. And then I left. So, anyways, that was the last time I did that. But anyways, so we get this is craziness, right? So we talked about the bars, about membership, no authority to regulate the public, create a monopoly. So of course it's a monopoly on the practice of law. It restricts your access to the law in the courts or through the courts. So therefore it restricts your access to justice, really. Think about it like this. Our court system is our only means by which we can access justice. We did it that way on purpose. We gave the state a monopoly on access to justice so that we don't have, duels at high noon and kill each other. I mean, think about it. What other remedies do you have? Violence. So I don't think we want that. because it just escalates, right? So we agree that we're going to give a court system, a judicial branch of power, we're going to make it the monopoly on access to the law and access to the police power. So you have to go through the judicial system to get access to the police power. Let me explain that in regular terms. If I sue somebody for money who owes me money and I win, then I get I can ask the court to ask the police to go take my money from the person's bank account. That's how it works. It's an executive function that I got permission from the judicial function because I proved that I had the right to do it, you see. Thankfully, we have that system. So, but there's some,
Yeah.
there's some caveats here. So we have this system that's doing a lot of good, but there's some evil in there. And I'm going to share with you, some more. I'm going to talk more about something we've already been talking about, but I want you to show the foundation here. And so we're going to etch out here what kind of system we're in. So the bar is an ecclesiastical organization. It's a function of an ecclesiastical organization. I think the court system is ecclesiastical. Just like I know you guys can correct me on this, but the fall of the Roman Empire, which took a few hundred years, okay, the dissolution of the Roman Empire led to the church, I guess it was the Roman Catholic Church, basically running Europe for about 500 years. Okay. And I think from there, and thankfully, somebody had to do it, And so we have an ecclesiastical forum. I mean, look at how the attorneys act. Look how they speak. They pray for relief and all this stuff, right? Look at all their ceremony.
Robes and wigs and
Yeah. Look at all
and
their
gavels.
rules of procedure. If you compare the rules of procedure, how they're formatted, the rules look just like a Bible. So it is an ecclesiastical. That's fine, but just recognize what it is, right? It has rituals, structure. You take an oath. It has rules, etc. There's exclusivity. Uh, anyways, so the bar's own history admits its purpose is to serve the bar, not the public. It's integration of the bar. The Supreme Court says, it's good public policy, but for bar members, of course. Calculated to serve the best interests of the bar. Yeah, they're thinking probably as well, we're the smartest people. So therefore, we should make the rules and not be liable to the rules ourselves. It's always that way. If you go back and read old philosophy from, 2000 years ago, you'll see the philosopher king concept. All right. The indictment would be dismissed. Okay. So the state cannot criminalize refusal to join a private association. The bar has no constitutional authority. UPL statutes violate rights of association, right to counsel, equal protection. The bar's stated jurisdiction is legal impossibility. Stated justification is a legal impossibility, and no statute may be used to preserve a private monopoly, although it's kind of doing that. The indictment such an indictment would lack standing. It would lack privity, connection, right? There's no privity. There's no victim. There's no harm. There's no injury. And there's no state compelling interest. So an indictment of that kind would lack all those necessary elements. And so therefore, an indictment would be void from the beginning. It would be dismissed, right? So I lay that out to say, well, look what we're up against. But I don't want to say up against. I just want to say this is the framework from which we are beginning, which we're standing. Let's use it. In fact, we should probably copy it. If enough people do what I'm explaining here, we can have our own association of creditors to all those that are collecting our data. And we can actually make profit from it. I mean, not just a profit from the instruments that we're using, like the security agreements, okay? I'm talking about large organizations we could consolidate and do something. We can govern how this data is being collected and used. We can really govern it. We can do that outside of your legislative authority because we are the government. And we have provisions in place in law that allow us to do these things. I'm not saying we should be against our government. We're the ones paying for it. We should be advocates of our government, but we should use the law. We should use the law and make it serve our interests and make it be just and serve justice, okay? And if it means that some things have to go to the court system or that some things don't have to go to the court system, just realize what our access is because there is a way to access justice without involving the courts or lawyers. We can use, dispute resolution procedures. We can use arbitration, and we can use the court system to memorialize arbitration awards without deciding or being the arbiter over how the awards are issued. We can do that ourselves because we never give up our judicial authority. Okay. We conveyed it to a group of people who are elected officials or appointed officials and so forth on public funds. We allow those people to function in that capacity because it works for our society, but we didn't give up that power. I'll give you a quick story. There was a World Bank thing going on back in the 80s, I think it was in Argentina, and Argentina was growing some sort of crops and it needed funding from the World Health Organization to continue. So of course, the World Health Organization, a bank, lent the country of Argentina some money to do this thing, and the crops were not sustainable, right? So the farming effort failed after so much time. I don't know how long. And so the country of Argentina went back to the World Health or World Bank and asked for more money. And so the World Bank said, "Of course, we'll give you due." And so what the bank did was create more lien interest in the country on its resources, which of course the bank would do that, right? Why wouldn't it? But one of the interesting things it did was put a lien on all the water, including all the water that condenses above the land, known as clouds, and the rain. It put a lien on the rain. So you cannot
What?
use the rain without paying for it.
That was Bolivia
How
too.
can they do that?
That was Bolivia.
But was it
That was
Bolivia? Yeah,
Bolivia.
it was Bolivia. Yeah, maybe it was
Yep.
wrong. Yeah, it's one of those.
Yep.
But
They're doing that here too now.
right. Well, that's all.
It could have been
they're
both, but
tokenizing
it was
it.
definitely
Yeah.
Bolivia.
So that's a bit over the top, right? So what happened was the people got so angry over this. Of course, like everyone's like, "What?"
Should.
Right. So here's the rule. When the people are assembled in the town square, they are the government. Right? So that's what they did. All the people, and it's a small country. Many of the people, not all of them, but so many people came peacefully to the middle of the town. And all the people that are your mayor, your president, your Congress critters, all those people left because they knew the people are coming. And so when those people left, the other people came in and reformed everything and said to the World Bank, no, we don't care what the words are on a piece of paper. You're not doing that. So, we are that. We have that power. Okay. We never give up that power. We can't. So anyway, so the monopoly allows, they're very educated people. And so this uniformity allows for the perpetration of all these agreements, policies, and things that allow companies to collect our data. Now, I think we want them to collect our data to some extent because many times it pays for the thing we're benefiting from. But I think sometimes we're just not being compensated when we should be compensated. Like, I think we're getting not compensated enough when someone says, download the app on your phone and get a discount on this. I think that's a joke. I think that you should be getting more than what they're offering. Okay. They're offering just enough that they can get you to do it. And so what are they getting out of downloading the app? What happens? What are you putting on your phone? Imagine someone knocking on your door, okay? And you don't know who it is. You can't see his face. He doesn't say anything. He just knocks on your door and you open the door and let him in. And then you don't have any terms. You just let him in your house. And then you just go about your business and you leave him alone. And then you go to bed. It's time to go to bed. And then he's in your house. That's what you're doing when you download an app on your phone. You don't know what's going on with that application on your and they're lying to you about what they're saying, so just keep that in mind. So lawyers write up these policies and these contracts. So your state legislature somewhat dials back some, there's some, restrictions and so forth. But of course, these contracts and policies are written to overcome a lot of the legislation or create such a quagmire for remedies that it's not worth it for the normal person. Like how are you going to read let's just say a small example, a 47-page terms of service, right, for your phone, right? How are you going to read that and understand what your remedies are for the collection, use, and storage of your identifying information, and even know if you have a claim or a cause of action? How are you going to know that? I mean, how do you know what's being done with your data? I think the moment you allow your data to be collected, there's already a data breach. Your data is already being used for something you didn't consent to. But that contract that is written by these lawyers covers that because it's vague enough that it could be argued by a good attorney in a court if you try to sue for a remedy. But if you look further in the contract, you'll find out that you can't even take it to a court first, if at all. You're stuck with arbitration, right? Who's going to be your arbitrator? A lawyer. Who's going to represent you? A lawyer. Who's going to defend it? A bunch of lawyers. Lots of them. What are your chances? Pretty small. So where you have a remedy, and we've talked about this before, right? So I just kind of make the connection that it would not happen without the lawyers. I'm going to have to demonize them just for this. I'm not saying let's get rid of the bar yet. I'm just saying let's look at where the source of for all this, all these rules, okay? The reason why companies are doing it is because the contracts that are written indemnify the companies enough to let them do it. All right. And so forth and so on. So we know that the collection of your data has value. It has monetary value. But you're not giving a meaningful choice. There is no choice. Take it or leave it. If you don't accept the terms, you cannot function in society. This is not a meaningful consent. There's no meaningful choice, okay? Consent is just a fiction. You don't consent. A 47-page contract, okay, right away, I can tell you right now it's unconscionable. I didn't even read it. Participation in society requires that you surrender your data. Just give up. You can't get you cannot get agreement that way. That's like saying a kid came into my 7-Eleven and bought a soda. Well, he didn't consent because he was a child and his parents weren't there. You can't get consent from a child. So how can you write something that's been written by, how can you be held to something that's been written by many, many lawyers over a long period of time? And you as a consumer, you want to use a product or a service or a license or something and have to consent to that. I mean, it's not even reasonable because let's say you take the contract, you can isolate the terms, right? Let's say you can get a document with all the terms, which you probably can if you worked at it. And then you want to get legal advice on that. What would that cost you?
Right.
And
Right.
what lawyer is going to actually help you? And what lawyer is even going to be competent to know what's being done with your data to know whether or not you have a cause of action? It's impossible. But this is the world in which we're living right now. Too many things to say. Are any of you guys angry yet?
Yeah,
Steaming.
please.
Steaming. And it
We
does.
have
It sounds like duress and you're a contract under duress type of thing.
it's all that.
Yeah.
It's all that. Yeah, and it's unconscionable. So, but I mean, what are you going to do? So, let's say you sue for unconscionability, and so the judge says, well, you're using the phone. Don't use the phone. But judge, I can't function. I'll be excluded from society. Well, that's your problem. They're all using the same terms. It's a monopoly on everything. Okay. So what is our remedy? Well, let's look at what I got here for the here we go. Let me just give you a couple of bullet points. Okay. So I'm not going to share screen. I'm just going to go with this. So biometric data is private property. I mean, if you guys want to argue with me on that one, fine. Let's say why it's private property, because it's exclusive to yourself. It has value. It's transferable, and the collection of it is irreversible in the digital world. Now, think about it for a second. Your biometric data is a useful thing because it's been useful for all of time. Because when I come home from work and I come into my house and my wife greets me and my children say, "Hey, Dad," it's because they recognize my face, right? That's biometric data. But is it being recorded in some digital storage system in Wyoming forever? No. It's because my children recognize me, right? It's because my boss knows what I look like when I come into work. That's the guy I hired. Yeah, come on in. That's using biometric data. So it's okay, but if you want to record it forever and then make a profit on the dissemination of it, okay, I have something else to say about that.
And
Market
also
demand
refuse
proves value.
access.
What?
And also refuse access based on not giving biometric data.
Sure. Yeah, you're denied participation in modern society if you don't allow your private data to be collected. I mean, even at the grocery store today, look at all the video cameras from every angle. So it's coercive because there's no meaningful choice in modern society if you want to be in modern society, unless you want to live out in the woods. I mean, consent doesn't exist. Participation requires surrender. Government is private sector example. So the role of the state bar monopoly. Okay, this is where I tie it together. So only bar members can write these contracts. Who else can do it? No, bar members do that. Consent forms, privacy policies, government regulations. UPL laws suppress competing frameworks. Adhesion contracts, right, are written by these lawyers.
Yeah, yeah.
Yeah, courts are
Suppressing
staffed.
competition.
Yeah, and so when you get into the court system or even arbitration, which basically is a judicial function, you're stuck with the bar members, which have you don't have a choice even with bar members because they're all going to say the same thing. Why? Because not because of any law. Lawyers are going to say the same thing, just like in the fake pandemic. People did the same thing because they were afraid of professional exclusion. They're going to go along with it because of professional exclusion. They fear having like their career path truncated. Lawyers, doctors, they
Yeah,
all did it.
yeah.
Those who are still lawyers and doctors, those people who are still doctors today, I question their competence and I question their sincerity about actually helping people heal. Because those who were fired from their jobs did the right thing. That's why they were fired.
Mhm.
So the system exists. It's the uniform national architecture, okay, is what I'm getting at. So attorneys draft all biometric laws and agreements. The American Bar Association model rules provide national uniformity. So government agencies rely exclusively on bar drafted interpretations. Even judges are bar members. Your appellate court members are bar members. All competing systems are criminalized. You cannot do anything differently, otherwise you're a criminal. So how can there be consent? It's a jail. Now, I don't want to sound like, it's an ugly thing, like Escape from New York. Okay, I'm not saying that, but that was kind of a cool movie, anyways. But still,
Yeah.
just realize the boundaries. All right. Now, this is where we get into the money. Expropriation, taking stuff without just compensation. The takings clause analysis, unjust enrichment by corporations and agencies. That's what I'm talking about. Lack of compensation is deliberate. It's not a matter of accident. It's not incidental, okay? Absence of meaningful disclosure or negotiation, which goes back to adhesion contracts. You know, you have to click here, terms of use. You must check the box that says you read them. Therefore, you agree. If you don't check the box, you ain't getting it.
Hmm.
That's not consent, especially for something so important, a
Yeah.
fundamental right. Look at the ring cameras. You have a ring camera in your house, you don't have Fourth Amendment protections. Period. If you don't have Fourth Amendment protections because of the ring camera on your house, do you have Fourth Amendment protections for anything in your life? Because it could be argued that you waive them for everything if you waive them for some things.
Oh, wow.
Think about that.
Hmm.
What about the right to remain silent? Gone. Just because you had a ring camera. It could be argued. So, what is this though? It's the taking of fundamental rights, which I would argue. I mean, fundamental rights are more important than property rights. Property rights are important, but I mean, property rights are money. Privacy is a property right. That is money. Privacy is money. That's how I look at it. Legal mechanisms are here's what they're so here are the legal mechanisms by which they're avoiding liability. There's arbitration clauses in all these agreements. So you're agreeing to waive your rights to go to trial, have a jury trial, join a class action suit. Right? Class action waivers. You're not there's no waiver of sovereign immunity when it comes to your government agency. There's not a waiver of sovereign. There is a waiver sometimes. You'll see you can waive sovereign immunity, but it's kind of different when you're, in most situations, unless there's a tort, right? Third party data sharing immunities. And this is where we're going to get into something because we can overcome this. Lack of statutory private causes of action. Again, we can get over this. You don't have a right of action in most cases for data breaches, right? Only the government can sue and penalize companies, and you can't. So that means if you're the only victim, forget it. half the city has to be victimized, right? Or the whole country has to be victimized, or 45 million people have to be victimized before you have a claim or cause of action in which the government would act on your behalf and give you $45 if the government wins. You know, there's no remedy there. And so, of course, all these are written by attorneys. So biometric expropriation is the modern version of what I like to say. This is my argument. It's the modern version of attornment. Before attornment was about real estate. I'm going to make the argument that attornment today is about the taking of property of all kinds, tangible and intangible. So it's a little bit beyond the historic meaning of attornment, but how biometric extraction mirrors feudal property transfer. Okay, so biometric laws and rules mirror feudal property transfer. So what does that mean? I have private property rights. They're conveyed when I go uh, enjoy a service or a product in modern society. I have to give up my private property. I even have to give up fundamental rights in many cases. So the individual, we become a tenant. This is the nature of a feudal society. It's you don't have a property right. You're now the tenant of your own former property rights. You're like leasing them from the state, okay? The state becomes the new lord of your property rights, or the corporation or the corporate state, right? So bar monopoly prevents creation of alternative agreements. Remember, anything outside the bar operation is what? Criminalized. Courts are staffed by bar members, can't question the legitimacy of the system. The UPL doctrine blocks non-lawyer advocates. This is why we're even having this conversation. I'm a non-lawyer, and I'm going to tell you, I'm going to be your advocate, and I'm going to tell you what is possible because this is my profession. That's all I do all the time is I analyze this stuff. So structural conflict of interest. Think about it. Your lawyer always has a conflict of interest, a competing interest with you. The writers benefit from the policies they write. Duh. So here's the conclusion. Identity has become the final frontier of expropriation. I think that's what we can say right now. Bar monopoly has expanded from controlling the law to controlling identity or farming your identity or your likeness as a product, as a commodity, let's say. And so without reform or abolition of this monopoly, biometric property will remain subject to uncompensated seizure. So do you think you're going to abolish this system? No. Do you think you're going to reform it? No, not really. What you need is a private right of action that can be heard and give you access to the law. How do you do that? We have a remedy under the Uniform Commercial Code. So what we can do is put a lien on the collection, use, and storage of our biometric data, our likeness. And those who collect the data that we're aware of, those initial parties like Google and Apple and all these, AT&T and whatever, your DMV, your IP, your ISP, sorry, your ISP for your internet connection. Okay. We can make these companies the debtors. We can make your government agencies the debtors in a security agreement in which the consent is already given upon the moment that your data is collected. Per the UCC, all liens are statutory. Thank you, UCC. UCC has been adopted into law, statutory law, in all 50 states, I believe, which allows us to use the UCC as the statute that gives rise to the creation of a lien and sustaining of a lien. We can therefore impose a lien on the collection, use, and storage of our biometric data, which means we can now impose terms on that data, all kinds of terms. And one of the terms, I'm not sure I did a very good job in my example of the security agreement for the collection of your data, the one I've been talking about for a couple of years, regarding the Fourth Amendment. So one of the things I may add in there would be something like, in fact, we're going to have, I think Jim has, if you want to say something, Jim, I think we have a new subscription. I'm going to add some more content to it regarding this. But one of the things I want to make sure that's in there is that any publication of your data to parties that are not specifically named are done so without consent and constitute a data breach. And do not constitute a waiver of rights guaranteed by law, which means the Fourth Amendment. Okay? A provision such as that should be in the security agreement. So you're saying there's not a waiver just because there's been a data breach doesn't mean I waive my protections that are available under law. Okay. I'm not saying my rights to privacy come from the law. I'm saying they're protected by the law. I already had the rights to privacy before you guys formed the country, right? People had these rights before they formed the government that's now protecting those rights. So what's happening is the corporate world, in the name of profit, is trying to create waivers of those rights for its own profit. And so they're using this system, this very strong association to do so. It's very strong. But that just tells us what we need to do. We need to have an association of people that are doing these things. I really hope that this catches on as somewhat of a trend. So, I mean, you can go back at my other videos and see what I'm talking about on creating this lien. And I think somebody was telling me earlier today in an email, he was telling me he used that AI to create his own lien on biometric data. Certainly, you should do that. You should do that. I mean, I have a course on doing it. Why reinvent the wheel? We could come up with, I mean, one of the key elements here is to determine who the heck is getting your data. I like to go with the organizations that are interacting with consumers myself first, my retail interaction. Because if I do retail interaction and I have my data security agreement written properly, it's going to include everything else that happens with that data when there's other interested parties that acquire the use of that data. So I'm going to bind the first party to the liability for transferring my data to parties that are not disclosed to me. Makes it simple, right? So we don't have to do research into who's buying the data in the background. We just have to put a lien on the first party, and your lien follows the collection of your data. Just like if the IRS puts a lien on your house and you transfer the title of your house, that lien stays. It follows the title of the property. Same thing with your data, your security agreement. It should follow the conveyance and the dissemination of your data in which that lien was first placed. Anybody want to add to that? Because that's all I'm going to talk about for this evening.
I had a couple of things, John, but
Yeah.
if it's not, if a couple of things while you were talking, one is in American jurisprudence, any statute law that is not in agreement with the Constitution is not lawful.
Oh, sure. Yeah.
There's a whole section on that, but often that doesn't get mentioned. The other thing, two other things. I've been watching two criminal cases on TV,
Yeah.
and it's been fascinating to watch how they bring everything together through the collection of data. And we
Yeah.
often think of cell towers, but they can actually not only ping from the cell towers, but they can determine that a phone is in a trash bin and not in the building 6 feet away, or it was in the building 6 feet away, and then it went to the trash can, date and time. It's really
Yeah.
fascinating to.
Yeah. It's interesting to think about this. Imagine Tesla is driving in the roadways, okay? Think about Tesla's driving around. Teslas have cameras everywhere. Teslas are watching you. I think Tesla is grabbing your phone data and the data from the headboard on your car when you're driving near it. And I think that data it's forming a network of data, like a grid of information that you could just dive down deeply into all kinds of information. And I think that's being sold or leased back to the Department of Transportation and anyone else who's in the world that wants to get it.
So the Google car, the people that were, when they were going around mapping using the Google car, there was a department that had to be disbanded because they were capturing all the servers and the data as it
Right,
was traveling along. So they
right.
got busted for that. Same thing with Pokemon.
They're
It was
still doing
doing the
it.
same thing. Yeah,
Yes.
yeah, they still do it. But
So
people
your
get
phone
caught.
data is being taken by your
Yeah.
Tesla driving next to you.
And so just one other thing I want to say, I had worked for Fluor Corporation, which was one of the largest engineering firms in the world, and we worked on the implementation of SAP. I was on that project. And because of my concern for privacy with what I was seeing, what was happening, they put me on a portfolio project. And since we were going not only domestic but international, um, people don't realize data is being kept in servers offshore, even like say your
Sure.
local college.
Hmm.
And if I did it just as an exercise, you follow your local college terms of service. And it turned out that a local college in Southern California, all the data was being kept in Canada.
Okay.
So
Wow.
that's why your lien, the first lien, is really applicable, because it's really difficult to find out where your data is being stored.
Well, what you do is you
But
make
that was one example.
what
Yeah.
you do is you make that debtor liable for wherever else
Yeah.
that data ends up.
Right.
Yeah,
So
and
that's why
whoever's
it's brilliant.
custody.
Yeah.
Yeah,
With what you're
it's a
doing.
oh yeah, it's very powerful, and just really take a look at this idea, and I hope many of you start doing this. I want to help you. In fact, I would love to have you watch the video series and use my document and actually teach others. In fact, if you wanted to, you could probably teach others for a fee. You could probably help other people do it. You could create a service that does it. More and more people should be doing this, because imagine
Hey,
if you have this. I mean, you have the liquidated damages clause in there. That's a lot of money. But imagine if you have like 40 or 50 of these liens and everybody has them, and you have like hundreds of thousands of dollars of receivables, right? And then some of those are subject to liquidated damages. And you have a private right of action through an arbitration panel of people like yourself, not lawyers, that can decide if there was a claim, right? And then award you damages, in which you go to the court and get a confirmation from the judge, and then go take their shit. How they like that? Explain that to your investors. Disclose that on your Form 10-K to the SEC.
hey, John,
Yeah.
this is Todd. I just thought I'd share. I had a meeting with a marketing expert to expand my business, and we were talking about how would we be able to do that. And he was explaining that billboards all throughout the interstate and through different streets are collecting your data as well.
Wow.
And right directly
Billboards.
from right directly from your vehicle. They collect all that data, and then they plug it in, and then they're able to, um, of course, just like Google or just like, whatever,
What's the
whatever.
biggest owner of billboards? It was like what was it? Like one name bought up like most of them. It was
I
some,
don't know, but
yeah.
I was flabbergasted whenever he was
Wow.
explaining
That's the
that. So they're
Department of
just
Transportation,
collecting
by
it.
the way, that permits those. But there's one company that owns like most of them. It's like a radio brand name or something.
If you have a really
Wow, that's
old
amazing.
car, can they
Hmm.
collect your data?
They're getting your phone data.
Oh,
So the
okay.
way you prevent that, by the way, if you want to, is just you put your phone in a Faraday cage. You can buy one. I think the one's called Silent Pocket. I have one in my truck. And if I want to, I just put my phone in there and I close it, and it's completely, I can't get a signal in there. So if I really was, because like if I'm at a traffic stop, which I don't have too many of those, fortunately, but part of the police procedure would probably be to look at my phone. So I would just put my
Another
phone.
thing is they have license, they have license readers, license plate readers
Oh, sure.
everywhere.
And AI
So,
can collect all your data and see where you've been all day. Yeah, sure.
and who the
Yeah.
car's owned to, and then,
Yeah.
yeah,
But
go
if you're
from
at a
there.
traffic stop, it makes sense to, first of all, remove your phone from your reach. It should be out of your reach. But before you do that, put it in a Faraday cage and throw it in the back seat. That way it's out of your reach and there's no signal. So if the police ask about your phone, don't answer. Don't say anything. Because they can't open the bag without a warrant. Yeah.
Yeah.
Yeah. So you
Oh,
can shove it under your seat too, right? So if it's out of your reach, or so they think it is, right? So it's just something to think about. But I didn't know the billboards were getting your data. But my suspicion was that Tesla is collecting your data for more than just, traffic safety. But doesn't it make sense? I mean, if I'm Tesla, I mean, I think Tesla is such a piece of technology that you could almost sell a car for like $8,000 and make all kinds of profit from the data that's being managed by it. It's all about consumer
Tesla
data.
is Tesla is also filming everything inside the car unless you turn it off.
Oh, sure.
Everything
Oh,
inside your
yeah.
trunk, everything inside your
Yep.
car, you have to figure
Yeah.
out how to turn it off.
Yeah.
Yep.
Imagine how many times you
That's
take an
through
Uber
another court case.
okay. Imagine you're taking an Uber and it's a Tesla. Do you want to really do that?
All right.
Yeah. So, anyways, I hope this gives you some new insight. look around, see that the grease in the machine is all these lawyers. But we can undo it all with a security agreement. We don't have to complain. It's so simple. You should be filing 50 a year.
So
You'll probably never keep up.
Karen put the link, thank you, Karen, in the chat for the course, Counter Strategies for the Collection of Biometric
Yeah,
Data.
thank you.
And
Yeah.
then someone else is asking, James is asking, if we already obtained your security agreement when you first introduced it, could we update it? How will we update it?
Yeah, if you already did that, please let me see what you have. Like if you send it to me,
I'll send it to you.
I would
Okay.
like to add that provision about I'll look it over again, like from scratch, like if I didn't write, as if I didn't write it. But I want to add the thing that covers all privacy that's guaranteed by law. So that where there's publication or conveyance of your data where without your express consent, that does not constitute a waiver. I put that in there. Yeah.
Right.
So yeah, if you want me to update something, please just send it over. No problem.
What was the last part of the sentence you just said that you want to add all privacy
What I want
guaranteed
to
by
do is,
law and then
yeah,
the waiver?
yeah, where there's been a publication or conveyance of your data, transmission of your data without your consent or in
Yep,
violation of the security agreement, that does not constitute a waiver of
yep,
protections that are normally guaranteed by law, including but not limited to the Fourth Amendment, which is kind of
Right.
what I just, said, but
And then
that's
that
what
could
I would,
apply to the retention places as well,
What?
like sending it out of state,
whoever's
sending
taking
out of the
custody of it,
country.
yeah.
Yeah.
But I always like to make the first party that collects it liable for everybody else that collects it that they give it to.
Mm-hmm.
Yeah, let them deal with it. Why should you have to deal with 200 companies? Just deal with the one and let them be liable for everything. All right. Well, I hope that it causes lots of trouble for where it should be caused. Don't get indicted for UPL though. It's ugly. All right. Well, enjoy your weekend, y'all.
You as
Thank you,
well.
thank you,
John.
John.
All righty. Thanks for joining. See you next week.
Take care.
Bye-bye.